It's a pleasure to introduce you Professor Zuzana Uhde from the Czech Republic. Zuzana, please.
Hello, so
Microphone or no video.
thank you for this opportunity to speak here, and I would like to thank to all the organizers of the conference, especially Marina and also others. So I'm going to speak about global justice and ethics of care. I'm going to speak in English because unfortunately I don't speak Portuguese. So if I am too quick or something you don't understand, please feel free to let me know. In my paper, I want to argue that the concept of care is a critical category for the articulation of principles of global justice and ethical and legal norms behind these principles. However, the concept of care allows embedding only some aspects of social critique, and therefore general normative propositions articulated from the perspective of the ethics of care are not adequately legitimized, and they are at risk to lapse into speculation about desirable social development. In the first step, I'm going to briefly outline the concept of global gender inequalities, the context, and care practices. In the second step, I'm going to explain the meaning of the concept of care. In the third part, I'm going to focus on the critique of approach to global justice formulated from the point of view of feminist ethics of care. And I develop my argument from the perspective of feminist critical theory building, in particular on the works of Marina. And in the conclusion, I'm going to outline how critical theory could provide a broader basis for the efforts to include care in global justice proposals. If we want to understand the current dynamics of gender injustice, the concept of care is an essential part of the analytical apparatus. We can define care as the preservation and development of intersubjective relations by looking after other people and things that matter to them or that are essential in order to satisfy their needs and develop their skills. Empirically, the concept of care refers to the intersubjective care practices. Care relations may include both very intimate relations between two individuals and socially more complex relations among a greater number of individuals. Normatively, the concept of care refers to the values of intersubjective recognition, attentiveness to the needs of others, and mutual support present in the care practices. The structures of gender division of labor and distribution of responsibility for the care for children, household, the elderly, etc. was in the center of feminist critique of the unequal position of women in society. In the changing context of neoliberalism and the intensive spread of capitalism, which means a tendency to commodify all aspects of social life, which is, according to William Robinson, a characteristic form of the expansion of capitalism in its global epoch. Public care institutions, a key aspect to lower the double burden of women, has started to be replaced by private ones. Feminists buy care services in the market. The personnel has not become political and public. Instead, the personnel has been marketized but remained private within the private economy. In the context of global capitalism, it led into establishment of low-paid and precarious caring sector that is characteristic by employing immigrants. Although not all care workers are necessarily immigrants, the phenomenon of employing immigrants as cheap labor force providing care has underlined problems of commodification of care. The idea of emancipation of women has partly been co-opted into the system of global capitalism and market logic driven by the profit principle. I describe this situation as distorted emancipation, by which I refer to the historical intersections of selective enforcement of only some feminist claims and changing social context of global capitalism. According to Ali Hochschild, today we should not only claim that the personnel be considered political and public, but also that the personnel be considered global. In a situation where the emancipation of some groups of women is in fact conditioned by fixating gender and social injustice for other groups, it seems more clear than ever that without social justice on the global level, the gender equality is not possible and vice versa. The feminist thinking has not always been successful in integrating the claims of all groups of women. In response to this failure, groups of women excluded from the mainstream feminism have stressed the need for internal critique that would take into account differences among women. However, as Marek Hrubec points out, the internal critique as such is insufficient and involves the risk of relativism insofar as it is not accompanied by an explanation embedded in historical development of social struggles and an analysis of positive normative tendencies present in the past and current facticity. The balancing of the three moments of social theory, as formulated by Marek Hrubec, critique, explanation, and normativity, provides the theory with criteria that prevent the trap of relativism in which postmodern feminism has been caught. According to Hrubec, the fundamental theoretical concepts should have a critical dimension, that means a potential to reveal the negative aspects of reality, or in other words, injustice, an explanatory dimension, that is an ability to capture and systematize the experience of the social actors, and a normative dimension to involve an outline of desirable ethical and legal norms of justice. The concept of care encompasses these three moments, but the interpretation by individual authors differ in what scale of abstraction they attribute to the concept of care, or in which regard they see the concept of care as a fruitful instrument for the theory. Care is a critical concept by which we can identify protests against two contradictory social trends: instrumentalization and commodification of social life on the one hand, and liberal separation of private and public spheres and the notion of atomistic individualism on the other hand. Care is also an important and useful explanatory concept for understanding mutual dependency in social relations and for describing gender relations in society, in particular with respect to the gender structure of division of labor and responsibility for the care for children, household, the sick, the elderly, etc. Last but not least, care is also a normative concept. Care relations include both bad and good facticity, being riddled with power like other social interactions. Normative extraction of positive norms present in the care practices does not mean that real care relations that are situated in the broader social context of power represent absolute compliance with these norms. However, these norms are fragmentarily present in the social reality of care practices. The concept of care as an analytical instrument builds on a relational care practice that differs from the dominant form of alienated relations in late modern capitalist society, in which there are positive fragments of reality that may serve as a basis for the normative criteria of social critique. Going to the main part of my paper, now I will focus on the normative level of the concept of care. I'm interested in the relevance of the concept of care for global justice. While the feminist ethics of care tends to colonize all forms of sociability with the concept of care, the feminist critical theory interprets the normative potential of the concept of care within the broader framework of the paradigm of recognition. The limits of the tendency to overburden the concept of care come to the fore, especially in attempts to incorporate the analysis of global inequalities and the perspective of socially misrecognized actors into the articulation of desirable ethical and legal norms of the global social arrangements. The scale of abstraction of the critical scope of the concept of care must correspond to the scale of abstraction of the normative propositions. Since the concept of care allows embedding only certain aspects of the social critique, general normative propositions formulated from this position are not sufficiently legitimized. Presently, the main proponents of the ethics of care are trying to expand the concept of care as a moral and political principle with regard to the changes in global interactions. Some of them emphasize that the concept of care may serve as a better underlying principle than justice, for example, Virginia Held and Fiona Robinson. However, they do not mention any other objection against justice as an adequate framework for dealing with global issues, than that the concept of justice and rights is inevitably linked to liberal atomistic ontology and affected by unacceptable abstraction from the real conditions of people's life. This objection has been rebutted by a number of authors, for example, Young, Fraser, Monet, Taylor, and others, who formulate alternative concepts of justice to the liberal theory. On the contrary, John Tronto represents a certain exception among the theorists of the ethics of care, in that she proposes a framework of justice, democracy, and rights linked with the feminist ethics of care as a basis for social arrangement considerations, on which she has lately started to work also at a global level. Nevertheless, like Virginia Held and Fiona Robinson, she too tends to overburden the concept of care. Tronto says, I quote, that we might get farther by calling the situation in which we find ourselves not simply capitalist or neoliberal, but as fundamentally uncaring, and contrast it with a vision of life that takes care seriously, unquote. And she continues, quote, what makes the current hegemony uncaring is its ongoing disregard for the lives of people, unquote. By embedding the critique in the reality of people's living experience, using the concept of care alone, she loses an instrument to systematically analyze structures that go beyond this particular experience and are not reducible to them, such as structures of global capitalism. Tronto does not thematize the causes of what she refers to as disregard for the needs of others or reluctance to consider them. In effect, she cannot even do that because the concept of care does not give her an instrument for the analysis, thus disallowing her to logically derive her normative theory from the critique of the insufficient elements of reality. Her normative theory is still suffering from insufficient legitimation. Analyses of the ethics of care in relation to global relations have been mostly developed by Fiona Robinson, who, unlike Tronto, prioritize care before justice. Conceptual ambiguities result from that Fiona Robinson confuses the international level with the global level. Finally, it seems that she inclines to the global framework for ethics, in the case of moral theory, and to the international framework for politics, in the case of political theory. On the contrary, critical theorist Iris Marion Young emphasizes that the scope, I quote, the scope of political institutions ought to correspond to the scope of obligations of justice, unquote, and not vice versa. So if injustice stems from global cultural hegemony and global economic order, the normative propositions must also be global. Fiona Robinson does not address this relation, while speaking about global ethics, which is pointing also to the global dimension of responsibility and obligations. She covers political institutions only at the international level. Therefore, the unit of her political analysis is a national state in plural. According to Fiona Robinson, moral obligations and responsibility towards others do not result from the existence of moral or political community or joint humanity, and she concurs with Young in this first point. Moral actors have, in her opinion, certain obligations towards others based on the fact that their individual existence depends on their relations with others. This second point goes farther than Iris Marion Young's social connection model of responsibility, counting with a structurally traceable yet indirect connectivity. On the other hand, Fiona Robinson fails to focus on a political, institutional, and legal framework that would correspond to the obligation framework so defined. Both authors refuse a liberal construction of the alleged ideal starting position and want to embed their normative projects in an analysis of existentially experienced form of injustice. However, Fiona Robinson seldom speaks about injustice, dealing with the negative aspects of reality through vaguely defined social structures of power and exclusion. Fiona Robinson's approach is narrower than the approach elaborated by Young. Robinson speaks for the excluded, specifically for the global poor women who are mostly responsible for care, for those who do not have access to sufficient care, and for those who have been structurally disallowed to actually carry out their responsibility to care. Surprisingly, Fiona Robinson leaves aside exploitation. While drawing attention to care, she fails to notice the causes of hardship that are primarily economic. Fiona Robinson considers care a pattern applicable to all relational practices. On the other hand, according to Young, care is one of the important forms of moral relational practices, but she also analyzes structural relations within a wider framework than that provided by care as an empirical referential point. Like Toronto, Fiona Robinson too tends to colonize all social forms, all social life with the concept of care, deforming its critical potential to a certain extent. So she must necessarily fail to maintain a conceptual unity between critique, explanation, and normativity, because her category of embedment of critique in reality, care, is too specific. For normativity, she then uses ad hoc categories that are not embedded in reality. Coming to my conclusion, I will briefly mention an alternative way how to relate care to global justice. Iris Marion Young used the generalization of concepts that are based on the care practices, relational autonomy, and mutual dependency to formulate a social connection model of political responsibility. Emphasizing the structural injustice enabled Young to disclose the sources of injustice situated in interpersonal relations, in the structural links between individual and collective actions, without necessarily having to identify the individual actors causing these injustices. The unintended consequences of emancipation of women as promoted in the Western late modern capitalist society have brought us to a situation where the structures of gender oppression and domination are being reproduced by those who themselves have been negatively affected by these structures. Nevertheless, by removing their individual burdens, they only take the oppression to a different level. The concept of social connection model of responsibility proposed by Young is very inspiring for the feminist theory. In the event of failure to meet the responsibility for removing unjust structures to the reproduction of which we contribute with our actions, we are culpable of disregard despite not having taken direct part in particular ill treatment of others. The culpability for disregard to the reproduction of unjust social structures then provides the necessary broader basis for the disregard to the needs of others as a manifestation of uncaring reality mentioned by Toronto. To sum up, the concept of care is not all-embracing, and articulation of ethical and legal norms of global justice requires extension of social critique categories. To say that is not identical with the conclusions of some authors who understand the concept of care merely as a moral ideal and link its benefits exclusively to the intimate sphere. In order for this to become clear, the concept of care cannot be perceived only as a moral category, but also as a political and social category. In late modern society, the social form of care concerns not only intimate relationships, but also social relations at a global level, both moral and material dimensions of social relations in the global context. Therefore, the concept of care provides an important insight for analysis as a category of social critique at a global level as well, particularly regarding the tracking down of the links of gender and social inequalities. Although the structural injustices cannot be adequately covered merely by the concept of care, the concept of care is vital for analyzing these structures. The concept of political responsibility represents a principle on the basis of which the ethics of care may be integrally incorporated in the efforts for global justice. Thank you.
Well, thank you for the invitation. I will make my presentation in English, and I will read my paper. And it's a long paper. I try to shorten it to 10 pages, and so I wait you pronunciation about the time. It's about the moral distinction, or what I'm claiming that there is an important moral distinction between morality and moralism. First, there is a quotation from Leonard Nelson from System of Ethics, and so let me read the paper. Morality and moralism are social and psychological phenomena. Both comprise a broad set of acts, practice, habits, beliefs, and sentimental and emotional dispositions by means of which people try to regulate and control the actions and behavior of others. Both comprise, to borrow a term from Law's Sloan, a lived morality. But what is the difference between them? By morality I mean a socially legitimate system of normative principles and rules for the positive regulation of human behavior. And I'll take moralism as the designation of a set of practices and attitudes, rather than as an actual system, or better yet, as the designation of a peculiar stance that lets people to falsely take their preferred system of duties as legitimate, like the prejudice that Anna talked about before. A normative attitude can be charged as illegitimate if a reasonable claim is applied to a context where it happens to be inappropriate. So moralism turns out to be problematic when people intend to live in accordance with it. One consequence is the promotion of behavior under the pretext of doing what is right and wrong and just beyond the positive legal rules that guide liberty and justice. Some philosophers famously took moralism as an equivocal but very effective psychological phenomenon. Nietzsche is the main example. His harsh critical stance to moralism nevertheless led him to adopt a kind of nihilist position concerning morality. Nietzsche's anti-realism on morality is probably a consequence of his own reactive attitude against moralism. I somewhat sympathize with Nietzsche's critical stance, but I don't think that morality as such reduces itself to moralism. Both morality and moralism comprise not only practice, habits, emotional and sentimental dispositions, but also beliefs. Beliefs are peculiar mental states. Philosophers of mind are still trying to clear up the distinction between states of belief and the other cognitive states, such as knowledge, and also between the cognitive conscious states and the assumedly non-cognitive ones, like the volitional and emotional. Cognitive states were usually taken as perceptions in the mind, and the emotional states were usually taken as pure volition, like Descartes' modi cogitandi. This is here the main reference. It is undisputable that we have cognitive mental occurrence, such as visual and other sensory perceptions, being they veridic or not, and that we also have affective occurrence, like emotions and bodily pleasures and pains. But beliefs cannot be reduced to any of those simple mental occurrences. Hume famously said that beliefs are complex or composite perceptions. He said that beliefs are ideas related to present impressions. This led Hume to reject the view that there could be something like moral beliefs. He argued that beliefs are ideas related to present external impressions, directly linked only to ideas of matters of fact instead of moral matters, or even to internal emotions. But beliefs involve not only perceptions and ideas, but also mental and behavioral dispositions, and they are certainly influenced by our emotions. It is also very plausible that beliefs are not only phenomenological mental states, that is, ideas related to present impressions. It is certainly meaningful to say that Hypatia believes that the earth is round, even when she's in bed or not thinking about it. Likewise, if we say that Locke truly believed in God's real existence, we are not describing any of Locke's particular phenomenal experience. As states, beliefs are not mere perceptions, although they require perceptions in order to occur as events in one's mind. But if beliefs are not reducible to external sensory perceptions, it is not, at least prima facie, implausible to accept that besides human natural beliefs, we may also have moral beliefs. That is to say, we have beliefs concerning matters of fact, but in addition to that, we also have true and false beliefs concerning moral matters. So, if I'm right, we can have moral beliefs besides moralistic ones. Since legitimate beliefs are true beliefs, moral beliefs are true moral beliefs. Moralistic beliefs, nevertheless, cannot be true beliefs, simply by definition. They are beliefs that express mere opinions, not any moral knowledge. They are false moral beliefs, perhaps systematically false. My view then is a kind of moral realism that incorporates a metaphysical and time-realistic position, but only to moralism. It's a criticism of moralism as well, but the fact that moralism can be wrong because false, it's different from the fact that it is unwise and imprudent, for this deserves further evidence and argumentation. Furthermore, I'm using moralistic in one of its common usages, like when someone says to someone else, "You are being moralistic about this matter, Marco," said supposedly to a rudely opinionated person towards homosexuality. This is not my case. Here the statement conveys the belief that the other person is wrong about some normative facts on the issue of homosexuality. In other words, there are rights and wrongs about the morality of homosexuality, and that the other person is not appropriately considered the issue. In this guise, my target is not morality, but certain distortion of morality, distortions that deserve the name moralism, as Tony Cody says, though in another context. But in the same context, using John Keek's analogy, my view is that moralism is opposite to morality in the analogous sense that scientism is opposite and usually prejudicial to science. So my view is a realist one. But it is different not only from Nietzsche's and Mackie's anti-realism, but also from the expressivist, non-cognitivistic views on morality. Expressivists think that moral beliefs simply do not exist. Some expressivists accept that we usually express beliefs in assertoric speech, but they also think that these assertoric statements cannot express a moral belief in a very strict sense of belief. Hume probably advocated the same opinion, so he avoided to use the expression moral belief, preferring to treat moral assertions as moral pronouncements, stressing that by means of those pronouncements, that one does not express any discovering about matters of fact. Nevertheless, Hume is wrong, and here I suggest that even Hume's moral pronouncements express literal beliefs. And even if Blackburn's answer to this so-called Frege problem against the traditional expressivist denial on the pretended meaningfulness of moral assertions were a good answer, and I'm not convincing, the fact is that we do make utterance with at least pretended moral propositional contents intended to express at least pretended literal beliefs. So we do believe that we have moral beliefs, and we usually try to communicate them to other persons as well. And note that when we do that, we use different statements from the typical prescriptive statements like commands and advice. Suppose Peter says that Hitler was a madman, or Helen says that her friend John is wrong in lying to his boss that he was ill for the sake of merely staying at home. You're not going to work. Both Peter and Helen have moral beliefs. That is, the belief that Hitler was a madman, and the belief that John acted wrongly in deceiving his boss about his intentions. Anyway, both statements are made in the assertoric mode, and this is a linguistic fact that deserves explanation. Well, one good explanation seems to be just that the assertoric speech has the function of transmitting or communicating Peter's and Helen's, respectively, moral opinions concerning Hitler's character and John's action. But Peter's and Helen's opinions about Hitler's character and John's action are nothing but their moral beliefs concerning them. One could suggest, following an expressivist lesson, that their opinions are actually nothing but their attitudes concerning Hitler's character and John's action. But beliefs are, or involve, in a sense, also attitudes. For attitudes are states, and it is plausible that to believe is a state that at least involves cognitive attitudes concerning certain propositions, evidence, experience, and theories besides others' beliefs. The expressivist could amend, saying that the attitude is that of reproaching, perhaps in the first case of condemning Hitler, but those practical attitudes are plainly compatible with the cognitivist view, for it is just because they think that Hitler is a madman and that John did wrong in deceiving his boss that to condemn Hitler and to reproach John are morally, in a broad sense, appropriated. Moral beliefs are expressed by moral statements that intend, or at least pretend, to be true or not false. And if it were true that moral statements ever pretend and never express true moral beliefs, then there would be no moral facts besides the fact that people think there are. If Mack were right, moral propositions would have the very strange peculiarity of being false by a posterior necessity. They would be like the belief in the real existence of unicorns, a belief that following Kripke is a paradigmatic example of an a posteriori belief necessarily false. Now imagine a moralist who adheres to Mack's view. In fact, a learned ethical moralist can perfectly see herself as a kind of nihilist without inconsistency. Moved by a kind of scientific spirit, she can eventually advocate a plain, realistic approach on ethics, accepting that all moral beliefs do not express moral facts, that they only pretend to express them, but that they are nonetheless necessary to life and politics. Realizing this, she can embrace a moralistic stance without compromising shame. It's without surprise that we have in international and even domestic political theory several pragmatic approaches in defense of the political utility of morality. After all, even if moral beliefs are plainly false, the plain and crude fact is that they stimulate behavior and move people to action. So a nihilist could turn herself into a less severe moral skeptic, embracing a consequentialist justification for moralistic practice. There could be good reasons for such consequentialist beliefs, because regardless of the fact that moral beliefs are false, the consequences of having them are good and useful. Moreover, figuring out that there is nowadays any other secure and effective technological way to improve or enhance people's disposition to promote people's welfare, this skeptic consequentialist can realistically find herself without any other solution but to preach morality. Something very similar can, and in fact, occurs in some religious persons. A religious can find herself without any grounds for believing anymore in God, but she can believe to preach as long as she thinks her faith is nevertheless a useful and prudent guide to her and to others' behavior. For nihilists, moralism is a kind of systematic bad faith, or maybe a kind of false consciousness, and a consequentialist skeptic can agree with that, but with the complementary belief that moral beliefs have a positive rather than a negative social role. For this kind of nihilist, it is not as such bad to act by bare faith, and even bad faith can, by disguise, eventually prove itself as socially good. Skeptical naturalists can think that there are evolutionary explanations for this social phenomenon, and at least in part they are certainly right. Though, in spite of that this is partially true, many disagree. For there are good reasons to think that there are at least some moral beliefs that are in fact true. If this is sound and metaethically true, then moralism is essentially different from morality. By morality or morals, we should denote only what is current, hence actual and effective. Agreeing with Kopp, it is difficult to take seriously the idea that all moral claims are simply false. The nihilist view implies that there are not any justified moral standards, but considers the very plausible claim shared by almost all moral philosophers I know, that if a moral statement is true, an enforceable consequence follows. Let's follow Hart and call this the view of the enforceability of all obligations. This was criticized by Robert Nozick in his book, the famous book, Anarchy-State and Utopia, but I will skip the discussion. I think Nozick was wrong here. If a moral statement states a moral fact, that is, if the moral sentence is true, the moral fact can be presented as a reason, perhaps not necessarily sufficient, but still at least a pretend to reason for some enforceable command, directly usually to another person or for an agent's own action. Well, it is a common view that morality implies enforceable advices or commands. Now consider the nihilist view that in trying to figure it out, how it could be possible that false claims warrant enforcements. Take, for example, the general view that reasons for actions. Reasons for action are facts that warrant decisions or actions. This is Bra's definition. It's disputable, but this is plainly acceptable. So there should be reasons for action in general and for moral actions in particular. Now, if there are also reasons for moral actions, so or these reasons are facts or either falsities, could be presented as reasons. But isn't this last possibility simply insane? Hence, reasons for moral actions must be only facts. But if there would not be moral facts, only natural or non-natural, non-moral facts could be offered as reasons for moral actions. But how could it be possible for a non-moral fact to warrant a moral action? Wouldn't that be a plain violation of the, though so misunderstood Hume's law? Hence, if there are actions morally warranted, and if those actions are the kind that are susceptible of being enforced by means of advice, commands, and acts, then the reasoning that rightly concludes that those actions should be done, or ought to be done, must be supported by at least some true moral beliefs. I conclude then that moral beliefs can and should express true moral beliefs, and this includes beliefs on duties. But how could we know that a moral belief expresses a fact? This is another problem, it's a epistemological problem rather than metaphysical, and I don't have space to develop it here. So let me go back to the semantics of moral language, more specifically to the semantics of duty. This is the second part. How many parts? Oh, okay. Philosophers do not agree about the scope of morality. They even agree actually about the meaning of morality. So let us take morality something in the terms of Leonard Nelson's definition, this is above, that is as the domain of duties. Nelson understands morality in a restrictive scope, which led him to differentiate real morality from mere moralism. For if morality is restrictive in scope, this implies that moralism cannot be valid. Nevertheless, Nelson's view is that morality should restrict itself to negative restrictions on behavior. Nelson's and my friend there thinks like this, no? Azevedo. But this is not sensible. Sorry. There are claims to positive actions, and not only to omissions. Hence, if moralism represents this, though invalid, attempt to positively regulate social behavior, then moralism must be taken serious and as an issue of the theory of morals, at least in the critical level. Nelson's restriction of morality to the theory of duties turns duty the main concept of moral theory. It's controversial, but let's assume that the concept of duty is in the core of the domain of morality. It's plausible, nonetheless, that there are different kinds of duties. We have duties as citizens, duties as spouse, duties as teachers, as physicians, and other professional jobs. We have also duties as friends, as fellows, etc. Some think that we have duties simply by the fact of being human beings. I don't think so. In spite of this, all duties seem to concern morality. Several thinkers claim that our duties concern obligations of justice. This is the case of Nelson. Justice is certainly in the core of the domain of morality. The other notions are either outside or in the periphery of morality. Care? I don't know. These notions can be inside or outside the scope of morality depending on other characterizations. See, for example, the notion of goodness. Certainly there are moral goodness besides several other kinds of non-moral goodness. Several things can be good. My car can be a good car. Judith Thompson's toaster can be a good toaster. A wine can be a good wine. And so on. But of course, those claims do not qualify those objects as morally good. But in the case of duty, it's different. Certainly cars, wines, and even Thompson's toasters are not the kind of things that can accomplish any duty at all. Could we say that animals can fulfill duties? How could they do that? We can command an animal, but it does not imply that if the animal complies with my command, that he or she is fulfilling any duty. The same applies to infants and people with mental disabilities. Only rational adults can bear duties. Kant is right in that. Even if other beings, including non-rational and non-human beings, can be the beneficiaries of them. Hence, duty is not like good and goodness, a term that can be applied meaningfully to different contexts except moral. So duty is distinctively a moral concept, and duty is by the same token a distinctively moral term. Good, goodness, right, and rightness are not especially or distinctively moral, for they can be employed meaningfully outside the moral domain. Duties as such are also distinctively social, even if there would be duties concerning oneself, like Kant thought about the duty of not committing suicide. Kant was wrong about that. They would only be meaningful in social contexts, but that's not consensual. Let's take duty as a moral term by excellence and morality as eminently social. Now, morality, of course, can be viewed as in a broad and in a narrow sense, but it can also be viewed in a very broad sense. This very broad sense of morality is the sense that includes it in the field wonders and questions about issues like the search for personal happiness and for what makes one's life meaningful. But today, morality is basically viewed as social morality. That is the notion behind Scammell's, for example, idea that there is a set of things and actions that we owe to each other. This is the narrow view of morality, and in this case, duty and moral duty is presumably the core notion of any social positive morality, since the function of duty is, in a very broad sense, to regulate social behavior, and to regulate social behavior is positive. It's not other kind of moral system. All duties, in effect, coincide in its range and meaning with and only with the requirements of positive justice. Let's take again Nelson's critical view that by a moralistic guise, every action is either a fulfillment of or a violation of duty. This view expresses an absolutist view of morality, and this is plausibly the common sense moralistic view. Let's call this simply moralism. What this implies? Take alpha as a symbol of some action. The moralistic view, then, is the view that either alpha is a fulfillment of duty or it is a violation of it. Take S as a subject. Then, either the assertion that S has a duty to alpha or the assertion that S is forbidden to alpha is true. Note that by this guise, permissibility simply means duty. For if S has a duty to alpha, then S has permission to alpha and is forbidden to not alpha. But in this case, if S is permitted to alpha, she is necessarily under a duty to alpha, for if S is permitted to alpha, she cannot be forbidden to alpha, since forbidden simply means not permitted to. The only remaining possibility is that she is under a duty to alpha, otherwise she would be prohibited to do it. Note that moralist conveys us with an insane deontic logic. Duty implies permissibility, but in all deontic systems, permissibility does not and cannot imply duty. If permissibility would imply duty, duty and permissibility would be deontologically tantamount. But duty and permissibility are not and cannot be equivalent modal notions. The statement that S has a duty to alpha is not equivalent to S has a permission to alpha, for the permissibility to alpha does not imply any duty. One consequence of moralism is that in extending duties outside their proper domain, the modal idea of permission simply becomes meaningless. This is of great consequence for the discussion on moral permissibility. Today, philosophers talking about moral permissibility, even Scammell talk about moral permissibility, but sometimes I think that he's talking about duties. This is confused. This is true because duties implies permissibility. But we can speak of permissible actions in other two distinct senses. An action can be permissible even if it's not required by duty. Common sense views see this action as morally permissible. But in a non-moralistic guise, it is simply permissible. Forbidden actions cannot be required by duty. But permissible actions can be required either by duty or by other broad moral requirements besides supererogatory actions. But permissibility includes actions required in a broad sense morally, not exactly by duty. They are actions that deserve our praise for the fact that their agents have done them with no personal interest, but for the best reasons, sometimes even at personal costs. Note, nevertheless, that no one has a duty to perform neither supererogatory actions, nor permissible but commendable actions. And this is important. No one deserves reproach or censure, blame or indignation in the case of omissions. This opens up a case for the notion of moral ought. Ought is not as such a moral notion. Like good, goodness, right and rightness, more wrong and wrongness, ought can be employed outside moral domains. Nevertheless, it's certainly meaningful to say that a person morally ought to do something. So what is the relation between our duties and what we ought to do? It seems acceptable to say that if S has a duty to alpha, then S morally ought to do alpha. It is possible by an arrangement of circumstance that although in fact S has a duty to alpha, that she actually does not ought to do alpha. I'm not sure if, in this case, we should say that S morally ought not to do alpha, besides the fact that she has a duty to do alpha. I prefer simply to say that in this case, S ought not to do alpha, besides the fact that she actually has a duty to do alpha. That she has a moral pretended reason to do alpha, but all things considered, this is not what she actually ought to do. It's not easy to present examples, but all examples are subject to controversial discussions, especially by us. Take anyway the duty of not lying. Suppose that Smith has a duty not to lie. Smith is a witness of a crime, and in a trial, the judge asks to Smith to tell what he knows about the incident. Smith fears that if he tells the truth, he or somebody of his family can be in danger for the murderous spree. Thinking about what to do, Smith decides not to tell the truth. Suppose that Smith was right. The murderer almost certainly would harm somebody of his family if he tells the truth. This is a case where we could say that S, Smith in the case, has a duty to do alpha, to tell the truth about the incident, for he's a witness, but in fact, S ought not to do alpha. That is, that Smith ought to lie and act against his duty. Would you say that in this case, Smith morally ought to lie? Why? Would we say that Smith had two conflicted duties, a duty to tell the truth and a duty not to tell? In which sense Smith has a duty not to tell the truth, yet he doesn't have this duty. Nevertheless, to act contrary to his duty is what Smith ought to do. But although it is correct to say that Smith ought not to tell the truth, consider all the circumstances, to say that Smith had a moral obligation or a moral duty to lie in this context is beyond the truth. This would be an example of why I'm calling moralism. After all, if Smith decided to tell the truth, he would certainly be accomplishing his duty. Another way of showing the difference between an action that we ought to do because it is required by duty and a permitted action that we ought to do by several good reasons, perhaps moral in a broad sense, is pay attention to the different reactive attitudes displayed in the case of non-fulfillment of a required action. See indignation. Indignation is a vicarious and reactive attitude we normally display in face of the belief of others' rights violations. And also reaction we display against others in face of their violation of our own rights. Suppose a case, the same case again, but let's substitute Smith or John. John has also a duty to tell the truth since he is in a trial, but suppose now that he doesn't have any good reason for doing otherwise. John then lies. One can feel indignation by John's behavior, especially if John's lie contributed to cause an injustice. But suppose now Peter, which like Smith, had good personal reasons not to tell the truth. In Peter's case, we probably also excuse him for lying, and our reactive attitude of indignation would be markedly different or diminished, or in some cases even suppressive, depending on the stringency of his reasons. But suppose he eventually does not lie. Yet what Peter did was exactly what was required by law. That is, he told the truth. Peter could have lied, of course, and in this case he would have approved him. We would have approved him, for he also, like Smith, had good reasons to lie. But contrariwise to Smith's case, in John's case, we would have gone too far if we had felt angry and indignant with him because he didn't do what we thought he should have done, what we think we would and should do in his place. Disappointment is perhaps the common and the correct vicarious attitude in this respect. So this is my point, and this is the last paragraph. Can I read? Maybe my example, I say too parochial, it's difficult to pick up. pick out good examples. Perhaps we should illustrate the same point by a hottest example. This is what I had in mind, the problem of dirty hands. But the problem with dirty hands example is that there are not any general rules that can support the idea of a moral warrant to those political practice for every casuistical situation. All tentative generalization on the problem trying to stipulate a general rule by means of which a politician or an official can be said to have acted by good reasons, besides the dirty one, are unsuccessful. But it's plainly possible to devise a general situation where a politician or an official has a duty to disclose information to public, and this is not occasionally what she ought to do. My suspicion is nevertheless that this does not apply for the situations frequently cited in the literature, especially those of war. In wars, an authority is usually not under any duty to tell the truth to the public. Hence, it is plausible that in periods of war, authorities are licensed not to publicize information that in times of peace they are under a duty to disclose. Someone could say that to lie is different than not to tell the truth. Maybe, but the circumstance can turn it in the same. It is possible that in times of war, authorities could have a privilege, as usually a legal privilege, to tell lies to the general public for the sake of military aims. I don't know. Anyway, the problem of dirty hands is more complex than the problem of the existence or not of a political duty to disclose information to citizens, even in those exceptional situations. Thank you very much. This is a part of
queria agradecer muito a invitação, especialmente a Itamar. Fico muito contente de estar aqui. Oi? Fico muito contente de estar aqui, ter a oportunidade de apresentar meu trabalho e ouvir os trabalhos dos colegas. I will read in English, and it's a resume of that text, so it will take me 15 minutes, I think. Well, the subject is about philosophy of law. It's a specific question that it is relevant for politics, democracy, division of powers, as we can see in, for example, in the debate between Alexei and Habermas about this subject. And in the title there is a question, it's a rhetorical question, and my answer is no. Judges should not abandon the deontological attitude when they acknowledge a conflict of rights. Citizens and judges should not balance. Citizens and legislators can and should balance, not just. The notion that the application of basic rights requires balancing, ponderação in Portuguese, is widely and increasingly accepted. Balancing judgments are even more frequently used in judicial decisions, particularly in constitutional courts and especially in contemporary supranational human rights courts. Many jurists deem that balancing judgments would not only be the most appropriate method to solve conflict between basic rights, but the only possible method to arrive to a rational decision, not just in cases of conflict between rights, but also in those that involve conflicts between basic rights and common goods. Along this line, Robert Alexi, the most influential philosopher of law advocating balancing, believes that seeing basic rights as principles implies understanding them as optimization requirements, and for that very reason, as only applicable by means of a balancing judgments. Principles are understood as norms that order that something should be done to the greatest extent possible, given the legal and factual possibilities. Evidently, the need to balance ensues from the specific conception of principles supported by Alexi. He states that there is a logical connection between rights and balancing. This does not follow from understanding that basic rights do not have the character of rules but of principles. It follows from understanding that all principles have the character of optimization requirements. This theory would be valid if balancing were always necessary in order to justify a decision in cases of conflict between principles. But that is not the case. Although this issue of conflicts between principles has only recently come up as a major concern in philosophy of law, it has long been discussed in moral philosophy. In fact, such is generally the structure of moral conflicts. And, as is the case with moral conflicts, the way conflicts are solved will depend on the underlying conception of practical reasoning. In what follows, I shall describe the two basic patterns that practical reasoning may follow in situations of conflict between moral principles in general, and I will argue against the idea that balancing is the most appropriate procedure to cope with the conflict, either in general terms or in juridical argumentation in particular. Moral conflicts are clear examples of the kind of normative clash that we are talking about. The collision between moral norms is sometimes termed external, situational, or contingent, because it does not appear in the abstract relations between norms, but only in concrete situations. Two valid norms lead to two obligations that cannot possibly be simultaneously honored. The most commonly used example to discuss the matter has been introduced by David Ross. I promised a friend that I would attend his party, but another friend is ill and needs me. My normative systems rules two simultaneous obligations. Promises must be honored and friends must be helped when they are in need. In the abstract, there is no contradiction between both norms. In particular cases, however, they can collide. Since the conflict cannot be solved stating that one norm or that one of the norms is not valid, we must decide which of them will be given priority in the actual circumstances. Norms are still valid after we have come to a decision. That is precisely why the issue had witnessed intense discussion in philosophy of law in recent years. Traditionally applied criteria to solve antinomies in the field of law, hierarchical, chronological, and specialization criteria, cannot be applied in these cases. That is why, so the reasoning goes, it is necessary to balance. I think, however, that the idea of balancing may end up masking the true working of reasons. The idea of balancing usually brings to mind a strong metaphor, which is at least sold as the idea of justice, the metaphor of weight, and consequently, that of scales weighing things. It is an irresistible metaphor, but a metaphor nonetheless, and as such, requires interpretation. A rational decision implies justification of the decision based on reasons. But reasons are linguistic statements, and linguistic statements have not weight. How can we gauge the weight of reasons? The relevant point that must be discussed is how we do that, namely, what form of practical reasoning is used in these cases. In my opinion, we can basically distinguish two types of reasoning, teleological and deontological, nothing new. While in the first case, the aim is to reach a decision weighing goods or values, the purpose of the second is to produce a satisfactory argument that will prove that the decision is fitting to the case in view of the presupposed normative system. In the first case, the decision is consequentialist and follows the logic of good. Its point is to find the best solution, the optimal. In the second case, the aim is to find the correct solution. Reasoning is non-consequentialist and follows the logic of duty. In moral philosophy, it was David Ross, a deontologist, who introduced the idea of prima facie duties as opposed to definitive duties, precisely with explicit intention of accounting for conflict situations more satisfactorily than does the consequentialist perspective. For Ross, understanding of prima facie obligations is, for Ross, understandings of prima facie obligation is not entirely clear, it is worth noting that the definitive obligation ensues from a non-consequentialist assessment of reasons. That is not the result of weighing the values at stake in the situation. We can see the problem from another deontological perspective, that of Kantian thought. It may sound paradoxical to ask how can concepts solve a normative conflict situations, since in the sole case in his entire work, when he mentions a conflict of duties, he actually denies its possible existence. But it is interesting to see why. Kant says that the conflict does not exist objectively. Conflict is in the subject, and is a conflict not between obligations, but between the reasons of obligations. Actual obligation does not exist prior to deliberation. Definitive duty only emerges in deliberation. That is why in Kant's view, strictly speaking, there can be no conflict of duties. Should the conflict be between independent obligations, it should be solved by means of weighing or or balancing that would attribute a different weight to each. Things look very different in the case of a conflict between reasons for obligations. Kant says that in this case, the strongest reasons dominates over the playing field. The metaphor suggests that in no way can the weaker reason occupy the playing field. It lacks effective weight in the situation. It is not that it does a minor weight. The obligation that ensues from deliberation is a decisive reason to act, and it cancels opposing reasons. From this perspective, we can picture the deliberative situation as an attempt to find a type of action that will better fulfill the many requirements and principles that appear to be relevant in the situation, and not as balancing among independent principles. The agent who works, on the contrary, exclusively according to teleological reasoning, finds a completely different setup. Doing the right things will be to choose the best course of actions, maximizing the realization of alternatives. In such cases, the non-satisfied obligation tends to have a residual effect. It was one of the conflicted values and still holds its weight. A metaphor from economics comes to mind, naturally. The obligation that was not honored, which is in this setting was a genuine obligation and not a reason for an obligation, must receive some kind of compensation, since the agent failed to honor it. There was an omission. Consequently, there is a debt to be paid. A responsible agent must balance things out. In this scenario, the rational justification of a decision can always vary in degree. There will be a more or less, a higher or a lower approximation to an end, and eventually a compensation of a minor harm for a higher good. Well, we have characterized the two basic forms that practical reasoning can assume in cases of conflict between moral principles. The reasons why I consider that the deontological perspective provides a more appropriate account of normative conflicts are based both on the conception of the agent and on the conception of the moral world. The deontological perspective favors the view of the moral world as a coherent normative system and a conception of a unified agent that retains narrative coherence. The teleological perspective, on the contrary, presumes a moral world composed of a constellation of values that, because of their very meaning, do not need to constitute a coherent whole. In that constellation of values, there is no need for the agent to attest narrative consistency, and it seems more difficult for him to hold it when, on principle, a constellation of values need not constitute a coherent whole. All that has been said may be insufficient to defend a given conception of argumentation in morals, but I do believe it is strong enough to advocate for a plausible conception of argumentation in law, namely, a conception that favors a coherent view of the normative system and a unified and consistent view of the decisions that the agent makes within it. Balancing is not inevitable, and it is not necessarily the most appropriate procedure to cope with conflicts of practical principles in general. Specifically, within the context of law, it is more appropriate to adopt the deontological perspective. I can see no any good reasons reason why, in cases of conflict of basic rights, judges should abandon the deontological stance that they must adopt everywhere in judicial decisions.
Thank you very much.